Good morning, ladies and gentlemen. Welcome back. You just remain standing. If you would, raise your right hand. The clerk is going to administer the oath to you as jurors in this case.
Do each of you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant, Michael David Dunn, and render a true verdict according to the law and the evidence, so help you God?
Yes. All right. Thank you, ladies and gentlemen. You can have a seat. And good morning, or actually good afternoon. Welcome back. Again, I want to thank you for your time and attention during the course of the last 3 days in our jury selection, and ask you to obviously continue to pay close attention to the matters that will ensue here this afternoon. You were selected actually yesterday and now have been sworn as the jury to try the case of the state of Florida versus Michael David Dunn. As you know from jury selection, this is a criminal case, and the defendant, Michael David Dunn, is charged with 5 separate offenses. The first count was first-degree murder. There are 3 counts of attempted first-degree murder, and the 5th count is shooting into an occupied dwelling. The elements of those offenses and the definitions that go along with it will be explained to you at the conclusion of the case. You should know it's your solemn responsibility to determine if the state has proven its accusations beyond a reasonable doubt against the defendant, Mr. Dunn. Your verdict must be based solely on the evidence or lack of evidence and on the law that I will instruct you on at the close of the case. The indictment that was talked about over the last several days, as you recall, is a charging document only. It is not evidence, and it is not to be considered by you as any proof of guilt. It is my responsibility to decide which laws apply to this case and to explain those laws to you. It is your responsibility to decide what the facts of the case may be and to apply the law that I instruct you on to those facts in order to reach a lawful verdict. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our justice system. Before we proceed, I would like to give you a little outline as to how the trial is conducted, so you'll have an understanding of what will come during the course of the afternoon and over the next several days. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement to you. The opening statement gives them an opportunity and a chance to tell you what evidence they believe will be presented during the course of the trial. What the lawyers say, however, is not evidence, and you are not to consider it as such. Evidence will come to you in the form of testimony from the witness stand, documents, photographs, things of that nature. Following the opening statements, witnesses will be called to the witness stand to testify under oath. They will be examined and cross-examined by the attorneys. Documents, as I said, and other exhibits, photographs, things of that nature may also be produced into evidence. After the evidence has been presented, the attorneys will then have an opportunity to make their final arguments to you. Following the final arguments of the attorneys, then I will instruct you on the law that applies to this particular case. After those instructions are given to you, you will be allowed to go back into the jury room to deliberate your verdict. As we've discussed on numerous occasions over the last several days, you should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the arguments of the attorneys, and the instructions on the law that I will give you at the conclusion of the case. Until that time, you should not discuss the case among yourselves. We've also talked about during the course of the trial, we'll take breaks. You'll have bailiffs with you during those breaks because of the sequestration issue. But during those breaks, you'll be allowed to do some other things. You should not discuss the case among yourselves or allow anyone to discuss the case with you or in your presence. If someone were to do something such as that, obviously, as we've discussed before, you would inform one of the bailiffs and they will tell me and bring it to my attention. We can handle the matter from there. The reason for that is, as again we've discussed on numerous occasions, is the case must be tried by you only upon the evidence presented here in the courtroom during the trial, in your presence, my presence, the attorneys, and the defendant, Mr. Dunn. You must not conduct any investigation on your own, as we've also discussed. This includes reading newspapers, watching television, or using a computer, a cell phone, the internet, any electronic device, or any means at all to get information related to this case or the people and places involved in the case. This applies whether you are in the courthouse or at the hotel during your sequestration. Obviously, you must not visit any of the places mentioned, and you should not look at the internet to try and observe anything along those lines. You must not have discussions of any sort with any friends or family members about the case or the people and places involved in the case. So even during visitation with family members, as we've discussed, you should not have any conversations with them about the case itself or the facts and circumstances surrounding it. We've talked a lot about this electronic age and the communication devices that are available to anyone. I need to stress to you again that you must not talk about this case, obviously face-to-face, with anyone, nor through any electronic device. You will not be able to use phones, computers, or other electronic devices to communicate unless it's under certain supervision. Do not send, accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on the internet or a website or such as that. You should also know, and we've discussed this somewhat over the last couple of days, that in every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of the defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and procedure. It is their duty to make all objections that they feel are necessary and proper. When an objection is made, you should not speculate on the reason why it is made, nor should you speculate on what the answer to the question would have been had I allowed the question to be answered. The pads and paper in front of you, you'll see there, are for your ability to take notes if you wish. If you'd like to take notes during the course of the trial, you may do so. On the other hand, you do not have to. You're not required to. It's just there for your individual use if you so desire. Any notes that you take will be, as I said, for your personal use. You should not take them with you from the courtroom. When we are on breaks, we will gather them up and watch over them for you, and the same thing in the evenings. When you have finished, when the case is finished and you go back for deliberations, you'll be allowed to take the notes back there with you for you to review, again, for your own personal use. You should not share your notes with any of the other jurors, and you should just use them for your use to help your own recollection of the testimony and the evidence. Also, let me caution you about getting too involved with note-taking itself. Different people take notes in different ways. Some people take notes almost verbatim, others are shorter about it. Do not let the note-taking distract you from what's going on. When the witnesses are called to the witness stand, the attorneys will be asking questions. When they ask a question and get an answer, they're not looking over to see if you have finished taking notes. They're going to continue on in this process. So be careful about that. Sometimes you're writing something down because you believe it to be very important. You may miss the next question and or the next answer. It may not have been particularly important, but it may have been. So just I caution you about that and ask you to be careful when you're taking the notes. Whether or not you take notes, you should rely ultimately on your memory of the evidence, the testimony that has come before you. You should not be unduly influenced by the notes of any other juror. Again, the notes are for your particular use. So if you were to get into the jury room and collectively as a group decide somebody was the greatest note taker you've ever seen, you cannot rely on their notes as a group. The notes are just for yourself. And as I said, your greatest tool is your memory of the evidence, but you can use the notes to help you with that. So with that said, we're ready to begin with the opening statements. We'll hear first from Mr. Guy on behalf of the state. Mr. Guy?
Thank you, Your Honor. May it please the court?
Yes, sir.
Counsel, good afternoon. As they had been so many times before, the two best friends were side by side. Jordan Davis and Leland Brunson, sitting in the back seat of a friend's SUV in the middle of a holiday weekend of mall hopping and girl shopping. But this moment was unlike any other the two best friends had ever spent. Bullets, 9 of them, had come crashing through the glass and metal surrounding them. Some of the bullets had whizzed by their heads and the heads of 2 other teenagers who were in the car. Some of the bullets had been stopped by the metal in the doors. But some of the bullets were unaccounted for. And so 4 terrified teenagers began an ominous roll call. Tommy, Tevin, Leland, Jordan. Everybody responded to the sound of their name, except Jordan Davis. He was lying in the back seat with his head in Leland Brunson's lap. Unbeknownst to any of them, 3 of those bullets had found their target. One of them had entered his right leg. One of them had entered his left leg. And one of them had entered his right side, tore through his liver, passed through both of his lungs, and shredded his aorta. And then the blood that for 17 years had run so naturally through Jordan Davis's veins and arteries was pouring out of them. And so the two best friends were side by side for the last time. Jordan Davis, gasping for air, was taking his last breaths of life. And Leland Brunson, who was cradling his dying friend, was taking his last breaths of innocence. And at that exact moment, the man who, fueled by anger and intent, had fired 10 times, 10, into a car of unarmed teenagers, was driving away, as though nothing had happened. Michael David Dunn pointed a semi-automatic pistol at 4 unarmed kids from a distance much closer than you and I, and then drove off. He didn't call the police. He went to his hotel with his girlfriend, and he called a pizza delivery man and ordered a pizza. He took his little dog for a walk outside the hotel, turned on a movie, and made himself a big, tall rum and coke. And not long after, an emergency doctor at Shands Hospital pronounced Jordan Davis dead. That defendant put his head on his hotel pillow and went to sleep. But ladies and gentlemen, as you are about to learn, there are some things that defendant will never, ever be able to run from. The physical evidence, the bullet trajectory through the car and through Jordan Davis's body, that will prove to you beyond any doubt that when that defendant opened fire, Jordan Davis was sitting in his car seat with the door closed, with nothing in his hands. And he was leaning over, away from the gunfire, toward Leland Brunson. Secondly, the words from that defendant's own mouth at the time of the shooting, words of hate, words of intent, words that he can't now take back. And most importantly, the memories. The wretched, indelible memories of the 3 boys who survived. And a host of witnesses at a gas station, including his own girlfriend, who he made witnesses to a homicide. The date was November 23rd, 2012, the day after Thanksgiving. Everybody knows it now as Black Friday. And 17-year-old Jordan Davis got together with his best friend, 17-year-old Leland Brunson, both of them students at Wilson High School. And as teenage boys are wont to do, they called two other friends to go to the mall to look for girls. So they called 17-year-old Tevin Thompson, a student at Atlantic Coast High, and 19-year-old Tommy Storms. And the four teenagers jumped into Tommy Storms' red Dodge Durango and went to the town center and struck out. The only person of note they ran into was Jordan Davis's on-again, off-again girlfriend, Aaliyah Harris. And then they climbed back into the car and headed for another mall, the Avenues Mall. But they stopped. They stopped at a gate gas station at the intersection of Southside Boulevard and Bay Isles Road. And Tommy Storms pulled in to a parking space right in front of the door, facing the store. Tommy Storms got out to go inside to get some cigarettes for himself and some gum for the other boys. And Tevin Thompson, and Leland Brunson, and Jordan Davis sat in the car listening to music. Their music. Loud music. Rap music. And then into their lives, and into the parking space right beside them, pulled the defendant. And after his girlfriend got into the store, he turned his attention to the boys. But before his girlfriend got out of the car, he turned to her and said, "I hate that thug music that was rattling his rearview mirror." And his girlfriend just looked at him and said, "I know," and went in the store. And rather than go into the store himself or move his car, the defendant chose to roll down his window. He was right next to Tevin Thompson. Tevin Thompson was in the front passenger seat. The defendant was in the driver's seat of his car. And he looked at him and said, "Hey, can you turn that down? I can't hear myself think." So Tevin Thompson turned the music down. But Jordan Davis, who was sitting behind Tevin Thompson in the rear passenger seat, didn't want to be told what to listen to, or at what volume to listen to it at. So he said, "F him, turn it up." And he didn't say F, he said the word. And he didn't say him, he said the N-word. But he said, "Turn it up." So Tevin Thompson turned the music back up. And then Jordan Davis and the defendant started jawing at each other. Jordan Davis is 5 feet 11 inches tall, 145 pounds. The defendant is 6'4" and well over 200. But they exchanged F-bombs back and forth. And at about the time Tommy Storms got back in the car, the defendant rolled down his window again and said, "Are you talking to me?" And Jordan Davis looked at him and said, "Yeah, I'm talking to you." And then the defendant said, "You're not going to talk to me like that." And in the same motion, he reached in his glove box and grabbed his pistol. And he pulled the slide back to chamber a live round. And with two hands, he pointed out his window back at Jordan Davis's door and pulled the trigger 3 times. Every one of those shots in a nice, tight little circle went through the door and into Jordan Davis's body. Tommy Storms, the driver, as you can imagine, was terrified and put the car in reverse and backed up. The defendant didn't stop. He kept focused and aimed on the car, and he pulled the trigger 4 more times. And you'll see the bullet holes in Tevin Thompson's door, one after the other. 3. The 4th shot missed. And then Tommy Storms backed all the way up and pulled off as fast as he could into an adjacent parking lot. But the defendant didn't stop. Instead, he opened his driver's door and put his legs out and took aim again and pulled the trigger 3 more times. Every one of those shots hit the car. 2 of them in the back where the taillight is, 1 of them in a rear window that crisscrossed the car, passing between all 4 of their heads. It came in the back right window and ended up in that little sun visor above Tommy Storm's head. Tommy Storms got out of the parking lot and stopped the car to see what was wrong, to see who and what had been hit. And they started that roll call that Jordan Davis couldn't respond to. And Tevin Thompson and Tommy Storms got out and they opened the back doors and they saw Jordan Davis and they saw Leland Brunson and they realized what had happened. And they jumped back in the car and they didn't park or turn it around where there was lighting and had already pulled off with his girlfriend, and the 4 teenagers were back in the gate parking lot. And people did come and pull Jordan Davis out of the car and put him on the ground and tried in vain. And you will be witnesses then. And you'll hear from each of the 3 boys who lived in the car. Leland Brunson, a wisp of a kid, maybe 150 pounds, maybe. And Tevin Thompson, big guy, brown face, smiles a lot. And they'll tell you about the interaction between Jordan Davis and the defendant. That Jordan Davis was upset, no doubt. He was cussing, no doubt. He raised his voice. But he never threatened the defendant. He disrespected the defendant. And Tommy Storms, the driver, who came back to the car and saw the defendant pull his gun. And you'll learn that Jordan Davis, the only thing he had on his person was a cell phone and a pocket knife. And both of those things were in his pockets when he was shot and killed. And when he cut his clothes off him, his little pocket knife and his cell phone were in his pocket. But you won't just have the people in the car. This happened at a gas station before 8 p.m. on Black Friday on the South Side. You'll hear from people like Stephen Smith, a contractor who stopped there to get something to drink, and who walked out the front door of the store. The defendant's car was the first spot next to the door, and he was stopped by what he heard the defendant say, "You're not going to talk to me like that." And he looked, maybe 10 feet to his right, and saw the defendant pull that gun and aim it out the door at point-blank range at the car next to him, and pull the trigger. And saw the red Dodge Durango back up and the defendant keep firing. And saw the Dodge Durango pull off and the defendant keep firing. You'll hear from people like Andrew Williams, who was on the street, and when he heard the shots, he pulled into the gas station. And he pulled Jordan Davis out of the car because he had a medical background. And he put his hands into Jordan Davis's chest in vain. You'll hear from people like Sean Atkins, who had the wherewithal to remember the tag number of the defendant's car before it pulled off. That was given to the police. People like Samantha Ickes, who pulled in just before the boys pulled back in and saw the holes in the car and saw the panic on their faces and called 911. You'll hear from people like Christopher and Alyssa LeBlanc, a brother and sister who had had dinner at the Loop restaurant, which is in the next plaza. They were walking back to their car when they heard the gunshots, and they saw the red Dodge Durango coming towards them and stopped suddenly. And they saw two black males, Tommy Storms and Tevin Thompson, get out of the car and look in the back. They didn't know what they were looking at, that it was Jordan Davis. They just saw him get out of the car. They didn't see him leave the car, the area of the car. They didn't put anything in the car. They didn't take anything out of the car. They just looked in the back. And then they got back in and put it in reverse. And the LeBlancs got in their car and they called 911. But you won't just have witness testimony, you will have forensic evidence. A bone-chilling audio tape. Because the Gates store has surveillance, video surveillance on the inside of the store only. And so you'll see Tommy Storms, tall guy, real skin, got dreadlocks, maybe down to his shoulders, go in and buy a pack of cigarettes and some gum. And you'll see the defendant's girlfriend, Rhonda Rauer, put a bottle of wine on the counter and a bag of potato chips. And then all of a sudden, out of nowhere, 3 remarkably loud bangs. The shots that killed Jordan Davis. And then a pause. 4 more shots. And then the long pause, where the boys pulled off and he opened his door. 3 more shots, all of which hit the car. And you'll have the car itself. The red Dodge Durango was at the scene, of course, and it was secured. And you'll see through the photographs that when the bullets went through Jordan Davis's closed door, it blew pieces of the inside of the door into the car, big pieces of plastic and rubber, into the car, because the door was closed. And they searched the car. There was a basketball in the back. There were basketball shoes. There were clothes. There were the big 12-inch speakers. There were cups on the floor. There were no weapons. And he yelled at her again, "Get in the car." And she did. And they pulled off, north on Southside Boulevard, maybe 3 miles to the Sheraton Hotel. They had cell phones, but the defendant didn't call 911. Didn't drive to a police substation. He drove to the parking lot. He put his gun back in the glove box, and he walked inside. He didn't tell anybody at the front desk. He just went upstairs. And he called a pizza delivery service to get a pizza. And he got his little dog, and he went down, he took him for a walk, and they turned on a movie, and he poured a big, tall drink, rum and coke. And then he went to sleep. But in the morning, Rhonda Rauer turned on the news, and it was a story of a shooting from the night before at a gas station on the south side in a 17-year-old boy had been killed. And she told the defendant about the news story. And then they packed their bags and went home to Brevard County, 2.5 hours away. And you'll learn that they had been at a wedding before stopping at the store, the defendant's son's wedding. And they skipped their plans for Saturday night in St. Augustine and drove back to Brevard County and unpacked their bags and went inside. But through the night, while the defendant was sleeping, the detectives were working. Remember the guy who wrote down the tag number, Sean Atkins? They ran the tag. It came back to the defendant. And in the middle of the night, they put together photo spreads with the defendant's picture, and they showed them to the three boys. Tevin Thompson, who was right next to the defendant, recognized, identified the defendant. That's the guy who shot Russ. And he signed his name. And they got an arrest warrant. And they went to Brevard County the next morning and arrested the defendant, who had not a mark, a scratch on him. And they seized his car. And in the glove box was a Taurus 9mm pistol with 10 rounds missing. And a magazine underneath it, another full magazine. And they searched that car. There was a shell casing on the front floorboard, right by the defendant's right foot. There were 4 shell casings in that little trough between the windshield and the hood that the expelled casings had been caught in, that matched the 5 casings at the scene. And you'll hear from a ballistics expert, Maria Pagan, with the Florida Department of Law Enforcement. And she will tell you exactly how the defendant's gun operates. What the trigger pull is, fancy term, is just the amount of force it takes to pull a trigger. And she'll tell you that to expel a single bullet, you have to pull the trigger 1 time. To fire 10 times, the person has to pull it 10 times. And she'll show you how the gun works. But ladies and gentlemen, you're also going to learn in this trial, as Ms. Corey discussed with you yesterday, real trials are not like TV. And the witnesses are not well-spoken actors and actresses. For example, Sean Atkins, the guy who was standing there, who had the insight to write down the tag number. He's in prison now. Since November of 2012, he's been arrested, prosecuted, sentenced to prison. Tommy Storms, the 19-year-old driver of the car, was on probation at the time, felony probation, and he had a curfew. He was supposed to be home at 7 p.m. He was violating his curfew when the gunshots went off at 7:38. And when you listen to the witness's testimony, you'll hear inconsistencies, real life inconsistencies, the way it happens in everyday life. And finally, ladies and gentlemen, you'll hear from Dr. Stacy Simons, the medical examiner who performed an autopsy on Jordan Davis's body. Critical testimony. And she will take you through and show you the path of each bullet. How 2 bullets entered the backs of his legs around his groin. One of which lodged in his left hip. And you'll see an x-ray of the projectile, and you'll see the projectile itself. And the 3rd bullet that went in to his right side, about midway up, and passed through his liver and his lungs and his aorta. And you'll see that the path of the bullet is like this because Jordan Davis was like this when he was shot and killed, leaning away from the defendant. And you'll see an x-ray of that bullet lodged in his chest. And ladies and gentlemen, at the end of this trial, Judge Healy will read to you the law that applies to all of us, the laws that apply to each of us. And we are confident that after you hear the evidence in all of it, that you will know beyond any doubt in your head, in your heart, in your gut, that when that defendant pointed that pistol at the car full of unarmed teenagers and started and continued to pull the trigger, he was guilty of shooting into an occupied vehicle, guilty of 3 counts of attempted murder, and guilty of the first-degree murder of Jordan Davis. Thank you for your time. Thank you, sir.
Thank you, Mr. Guy.